Good morning, everyone. This is the House Judiciary Non Civil Committee. We're here to consider several bills. I appreciate members of the committee coming here on Friday morning. This is that time of year where we have a responsibility to get these bills out as soon as we humanly can. I will tell you, just for planning purposes, we will have a meeting on Monday after our normal Monday meeting, and then we are likely to have a meeting as well on Tuesday morning, probably at the same time, 9:30 to noon time block. So just be aware of that. We're going to try to avoid a meeting, our Wednesday standing meeting, but we'll just see how it goes. We'll just have to take it as it comes. But just for planning purposes, obviously today, the normal Monday meeting, and then Tuesday, 9:30 to noon, and we'll go from there. We still have some bills that are in subcommittee and full committee that are being worked on, changes being made, in the hope that we can get them prepared for a motion. So with that, let's get right into it. Senate Bill 121, Senator Miller.
Yes, sir. Thank you, Mr. Chairman, members of the committee. Bring before you Senate Bill 121, and we are working from LC 297532S. And at the encouragement and wisdom of the subcommittee, we made one change. It was line 53 on page 2. And we added the words "in good faith" as it reflected to the state health officer. And this bill does two things. It creates a standing order for naloxone, and it names that standing order for naloxone, statewide standing order, and names it for Jeffrey Dallas Gay Jr.
And Senator, just for members of the committee's edification, I told the senator that he did not have to show today, that we would be happy to handle the bill for him, but he wanted to make a point, given the gravity of the subject matter and respect for the committee, that he wanted to come here himself and make sure that that he was before the committee, and we personally appreciate that. It wasn't necessary, but we certainly appreciate it.
I appreciate the latitude, but I respect the committee and appreciate there may be one day I can't be here. I'll need you then.
You'll have us.
Right.
We'll be there. Make no mistake. And just for the chair's clarity and for everybody's clarity, this is essentially codifying what the pharmacy board did, the action that they took last year, which was at the governor's request to reschedule this drug to be used as, and I may be saying this right or wrong, opioid blocker, and this is in direct response, obviously, to the opiate overdose problem, and it's used to basically to save people's lives.
Yes, sir.
And to revive them from.
Early December, and I think on record there are 9 lives on record having been saved with that since the executive order.
It's terrible that that has to occur in order to save a life, but it's very heartwarming to know that that kind of action actually has an impact and lives are in fact being saved, and that's just the first several of, unfortunately, there will be many more, but it's better than the alternative.
Yes, sir.
Okay. Questions for the author? Seeing none, pleasure of the committee.
Move to pass.
Moved to pass by the vice chair, second by Chairman Ballinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion, signify by saying aye. Opposed? The ayes have it, and the motion's adopted.
Thank you, Mr. Chairman, members of the committee.
Thank you, Senator. Appreciate your being here. And counsel, I should have said do pass by substitute, but I guess that's inherent just from what we're looking at. Senator Unterman, Senate Resolution 307.
Who's carrying which bill?
Got it? Okay, thank you. I appreciate it. Thank you, Mr. Chairman, members of the committee, for meeting on this bright St. Patrick's Day, and Aaron go Bra. So I bring before you Senate Resolution 307. This is very simple. Sexual Exploitation and Human Trafficking Joint Task Force. This bill came about as LC 372383. We were working on some sex trafficking legislation this year, and we were having some difficulty, and I think Representative Reeves can attest to this. And Vernon Keenan, the head of the GBI, came up to me and said, Renee, you know what the problem is with these bills this year? And I said, well, it's kind of the same old problem we've always had. And he said, yes, ma'am, it is. He said, you know, what we're dealing with is working within the Georgia code and case law, new case law. And the Georgia code is based on the old language coming from the 1960s when the adult entertainment industry kind of got a foothold, and we started revising the Georgia code in the 60s based around the sex entertainment industry. So the nomenclature and the language that we're using now does not match up because it's changed so dramatically in our culture, but the code hadn't kept up with it. So instead of using pimping and pandering, we're using trafficking and trafficker. And that type of language, we've been trying to hodgepodge it and correct it and do it over the last couple of years. And I just want to say thank you to former Representative Ed Lindsay and to Representative Buzz Brockaway, who started on this journey with me about 10 years ago, that we started revising the laws and changing the infrastructure. And Senator Efstration and now Representative Efstration and Representative Burt Reeves are taking over the mantle of this cause. But what Vernon Keenan says, we need to revise the code and do like we did with the juvenile justice rewrite and the criminal justice reform to update the code. So that's exactly what this task force aim is. It gives the history of the sex trafficking movement in the state of Georgia. And the composed members that would be selected on this committee are 14 members. And you obviously can read it. And I had another bill that questioned who was the membership on it. I think 14 is a good number. We brought forth the people that have worked on this movement all through the years, the CJCC, the Office of the Child Advocate, Attorney General, the GBI, local government, Prosecuting Attorneys Council, most importantly, the Vice Squad that we've worked with, a member of a Vice Squad that we've worked with through all these years, and a faith-based advocacy group. When we first started out, there was no advocacy groups except one, and now there's many, many advocacy groups. I don't care which one, just one of them. And a nonprofit agency that has experience working in this on this particular issue. So I think it's a great suggestion. I know that Representative Reeves is still very interested in Representative Efstration, and I look forward to working with y'all and working in the summer and fall and revising the code.
Thank you, Vice Chair.
Thank you, Mr. Chairman and Senator Underman. I want to take this opportunity to thank the Senate Judiciary yesterday for passing out what I think is something I know you've been involved with along the way, a very important and strong human trafficking bill that I look forward to working through the rules process. But in working on that legislation this year, I have become acutely aware of exactly what you're talking about with some of the issues with the terminology. And this is something that needs attention. It needs to be modernized. And I think that this is a very important effort, and I look forward to assisting you on this as whether an official or unofficial member of this. I look forward to being involved.
Thank you.
Any questions for the author? Seeing none, what's the pleasure of the committee?
Move to pass.
Mr. Reeves moves, Vice Chair moves due pass of Senate Resolution 307 LC 372383, second by Mr. Gravely. Are there any amendments? Any further discussion? All in favor of the gentleman's motion, signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you, Senator.
Thank you. Thank you.
Senator, who's carrying that for you?
Representative Reeves, if he would.
Okay.
Do you have time?
Always.
Thank you.
He dashed out before. Does anybody know who's carrying Senate? Mr. Efstration, are you carrying 121 for Senator Miller on the floor?
I'll get an answer to you, Mr. Chairman, by the end of the meeting.
Okay, great. Thank you. Let me call Senate Bill 16. Senator Watson is not here. He's from Savannah. This is St. Patrick's Day. Enough said. Representative Peake has graciously offered to handle that for him. It's the chair's understanding that there is the substitute that we have in front of us is a contemplated compromise agreement between the House and the Senate on the issue. Is that a correct statement?
That is correct, Mr. Chairman. We worked diligently, Senator Watson and Senator Greg Kirk, as well as from the Lieutenant Governor's staff, to try and come up with language that would be acceptable to both, to their chamber and to ours. And I think we've got a good resolution before you today. So.
Okay. Can you just very quickly let us know what the changes were from what we passed out here?
Yeah, is that what you want me to go from kind of what passed from HB 65?
Just the differences.
All right, the differences are, it does not, we passed a bill that added 8 conditions. This bill includes 6 conditions, so it does not include autoimmune disease and does not include HIV, which were passed by our chamber. It allows for reciprocity, but we imposed a 45-day limit on the reciprocity that was passed out of our chamber. It adds severe or end stage on 3 of the diagnoses that were added: Alzheimer's, AIDS, and peripheral neuropathy. It adds severe autism for those under 18. It adds Tourette's when in a severe state. It requires semi-annual reporting versus where we had 1-year reporting, and it requires that in the reporting that the THC levels be provided as well too. And Mr. Chairman, that's we had taken off the severe end stage from 5 of the existing conditions, and that was added back. So again, I think this is probably not as much as I would have liked, but I think it's a good compromise with the Senate. It is I would just mention to the committee, we have gone over this with a fine-tooth comb with the 2 senators that we've been working with. I'll defer to the wisdom of the committee, but I sure would like to see it pass out as is, because that is kind of the commitment I had with the senators, that there wouldn't be any changes to it. So
It's a little frustrating just because, and I understand and appreciate it and certainly will support it, and that's why we're here this morning, but it's a little frustrating in that, you know, if you go back and think logically, if we can go ahead and just bring ourselves to do that, you know, if we have trust in the process that we established through your leadership in the last few years, buying through DPH in conjunction with the composite board, and you know, having that pretty wired tight, and I think we've proven that it is pretty wired tight. I don't know why we would collectively really have any limitation if we have faith in that process, if medical professionals are truly making the decision, as opposed to piecemealing it year to year to year, end stage, not end stage, because at the end of the day, you're either taking steps to enable, not guarantee, but enable the possibility of people who are suffering being helped, and in some stages reversing,
right.
Depending.
That's correct.
I don't know why we would take a step backwards in that unless we were all doctors, and we're not.
Yeah. And I'm in total agreement with you. As you know, the way these things work, sometimes you give and take on issues that you wish you didn't have to. And in this particular situation, that was a pretty big point for the Senate.
Yeah, that was a temporary release of the idealistic side of my brain. But then having been here, this is the 19th year that I'm here, and I understand more than most that, you know, this is the art of the possible. So, but it still doesn't change the frustration level, because you're talking about a moral imperative.
Right.
Right. You're talking about a moral imperative.
Right. Right. And I'm grateful for your support and help through this process as well, too.
No,
So.
we wouldn't be here if it weren't for you. Ms. Kendrick.
Thank you, Mr. Chair. I had 2 questions. The first, could you repeat the 2 things, diseases that were struck
Yes.
from?
Autoimmune disease, which would include those with lupus or fibromyalgia or rheumatoid arthritis, and HIV. We did include AIDS when it's severe or end stage, but HIV was removed.
So the AIDS one is 56 through in 57, line 56 and 57?
That's AIDS is on, yes, 56 and 57, that's correct.
Any further questions for the author?
Mr. Chairman, can I just make a real quick commentary? I'm grateful to this committee for your help on this issue. As I've kind of been involved in it, it all comes down to people. You know, it all comes down to how are we, as you eloquently just put. I got a note this morning from a fellow legislator who basically sent me this text. Said, "Thank you for all you're doing. My wife has peripheral neuropathy. She doesn't like to talk about it. If people saw the pain, numbness, cramping hands and legs, and the side effects of the drugs they have to take now, they'd be advocates too. Thank you so much for your work." I mean, just a reminder that, you know, what we're doing, even adding these conditions, is going to make a difference in the quality of life for people we know and people we don't know as well too. So,
Well said. Thank you. We have to remind ourselves of that every now and then, don't
yes, sir. Yes, sir.
we? Yep. Okay. Pleasure of the committee. We're going to go to the videotape to see who actually.
That was pretty
and
quick.
then-
Pretty quick trigger there.
And the audio.
Mike,
So
I think she got you though.
I'm going to go under the hood for a minute and see the instant replay. And we'll be right back. There's a move due pass by Mr. Gravely, since he's physically closer. So that's right. That's my story, and I'm sticking to it. Move due pass by Mr. Gravely of Senate Bill 16 by substitute LC 297560S, second by Ms. Ballinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Peak.
Thank you, Mr. Chairman, members of the committee. Thank you.
He is. Yeah. Mr. Registration for Senate Bill 174.
Thank you, Mr. Chairman. And I just learned Representative Trey Rhodes, will be carrying Senator Miller's bill in the House.
Okay. Thank you.
Thank you, Chairman. Working off of LC 297550 ECS. Mr. Chairman, I'm excited to bring you two bills here today, and Senate Bills 174 and 176 that are parts of the criminal justice reform package for 2017 from recommendations of the Criminal Justice Reform Council in which I serve. The bills that we're discussing here today are in furtherance of the objectives that were originally set out by the governor and for which we have seen great results already, including a reduction in both violent and property crime rates by 15 and 21% respectively since 2005. The bill begins by ensuring that the sustained success of the accountability courts in Georgia continue. Currently, accountability courts are operating in 47 of 49 judicial circuits, and cleanup and availability of part-time juvenile judges for family treatment courts was necessary to include. There is also focus of the bill to improve the parole process by increasing prosecutor victim input opportunities, providing appropriate alternatives to incarceration that are available to probationers, and imposing conditions set by a judge which may be specific to a case during the parole term, as well as moving revocations for some parolees into Superior Court sooner to ensure prosecutors and judges control the process. Happy to provide the mechanics of this, but practically we're talking about individuals who are serving on parole with good behavior with a certain class of offense for which they were sentenced to meeting other criteria, having the potential to move from parole to probation after a year of time without incident. The objective here is to increase actually the supervision, that there would be an opportunity for local probation through with local judges having oversight to have the ability to ensure that who was a parolee continues to be compliant with the terms of his or her sentence and does not commit any new offenses. We are including in this bill as well that while on parole, the special conditions of probation would also be imposed. Therefore, the parole board would have the ability to enforce special conditions which might have been in place, which, as we heard at subcommittee, would include the payment of restitution at that time, which I know Mr. Reeves, as a prosecutor, is familiar with the need in that area. The bill would also allow for, upon 3 years of successful completion of probation without incident for certain classes of offenses, to allow that, to require that the probation department provide the court with order for an available decision as to whether to terminate the probation early. Those recourses are currently available. Unfortunately, many times it does not take place, even with model probationers who have done everything just right due to the mechanics of the system. They are not, they might not have counsel retained to submit these petitions, or there might be other obstacles for that to occur. Mr. Chairman, that's a sum up of the bill. I'm happy to speak to some of the specific changes from the bill as passed out of the Senate if you'd like. But otherwise, I'd ask for the committee's favorable consideration. I'd be happy to answer any questions.
I'll call on the vice chair for a report, and then we'll get some questions.
Thank you, Mr. Chairman. As far as my report, is this bill coming through my subcommittee, this is a bill that truly addresses some very what I call practical fixes to some areas of law and improvements, and really is a very logical step. And we're codifying some things that happen in court that are extremely practical, and I think very beneficial in terms of criminal justice reform. And so I think that this is an excellent piece of legislation that's much in line with the goal that I know this body has been after since before I even got here. So I thank Representative Evstration and Senator Kennedy and all of the others who have been involved with this.
Thank you, Mr. Chairman, for your thorough examination in subcommittee. We appreciate the comments you've had.
Ms. Quick.
Thank you, Mr. Chairman. Representative Evstration, my question really emanates from lines 139. It's not necessarily about it, but from it. The reference to the Family Treatment Court division, or the Family Treatment Courts. Do you happen to know how many family treatment courts, separate family treatment courts there are now? And could you just give me a Reader's Digest condensed version of how they function in and with juvenile court?
So I cannot answer the first question, but I can provide that to you, or I can ask to have that provided to you, Representative.
Thank you.
And I might have to rely on either Ms. Travis or try to get you some specifics as to the interaction between juvenile court and Superior Court. But as I understand the Family Treatment Court, it is the opportunity for individuals who might otherwise be in Superior Court on a child support matter, or as I've contemplated this, it's a child support matter, I believe, primarily, where it's not conducive to justice or the best interests of the child to have the party placed in custody, and that an accountability court framework might best ensure that there is compliance with an existing order. And my expertise is not maybe as far as it should be on this specific issue. So if you don't mind, if we, if it's okay, I'm happy to have us maybe meet with Justice Boggs or Carrie Miller and go through the specifics of that. Yes, ma'am.
I wanted to just follow up on the, you mentioned special conditions of probation. I just wanted to confirm, we had this was more than a dozen years ago, we had a glitch in the law whereby courts were actually unable in certain circumstances to revoke the balance of probation for violation of a special condition. Of course, a special condition could be, the first example that comes to mind, of course, is when an individual who's been convicted of, let's say, child molestation is not complying with with the part of the sentence, with special condition of their probation, I should say, that, well, they have to maintain a certain distance from certain places, schools and such. Is there anything in the bill that affects, I want to say negatively affects, but has a reverse intended effect on the court's ability to revoke the balance by virtue of a violation of a special condition of probation?
No, sir. To my knowledge, there is no change as to the court's ability in that area, other than the potential for the court to receive the option to terminate probation early. All right, but that is only after, say, for instance, restitution, which I think of as a special condition of probation until that is satisfied.
Mm-hmm.
So I guess maybe the only way that might occur is if the 3 years without further incident, all the other conditions have been met on the sentence, and the court then has the option to terminate probation, as the court does already.
Right.
But the petition would just be issued. The one area, though, I will highlight is currently there is an argument that parole does not have the ability to enforce special conditions of the sentence, that would only occur once the offender's on probation. And I can give you an example if you'd like, but the bottom line is, with this bill, we've not addressed that, so that parole can enforce the special conditions of the sentence. You don't have to wait until the offender's on probation for that to occur.
Any other questions, members of the committee? Ms. Silcox.
Yes, Representative Abstration. I know that Georgia has one of the highest rates of probation of any state in the nation, and I'm just curious if this bill, do you think, will improve the efficiency of that so that we can possibly cut down on the number of people on probation?
Yes, ma'am. We've heard testimony in the Criminal Justice Reform Council to the end that you've described, and I think the objective here is to identify the individuals who need additional focus and attention, or those for whom supervision truly is appropriate. And to that end, we've put this 3-year potential for, or automatic generation of a petition or option for a judge to terminate an order for an offender who might have completed the conditions of his or her sentence and has not had any subsequent issue, for the judge to consider terminating probation after 3 years.
Thank you.
Mr. Porter, let me ask you, I think it'd be appropriate just for you to maybe chime in, and from the prosecutorial perspective, and obviously criminal justice reform has an effect. I know this has been a very collaborative process. It's always attempted to be that. Any comments from your world on?
Well, I was a member, along with Mr. Spahos, of the meetings over the summer of the Criminal Justice Reform Council. And of course, it was a long give and take between advocates of a number of positions. This bill is a final result of that negotiation, where there were some things that were less than satisfactory to us that have now reached a middle point that we can accept. There were also some reforms in the parole area that we believe will allow for a more streamlined approach and a more unified approach to someone who is transitioning from prison to parole to probation, and a more unified supervision. So we're here in support of the bill.
My sense is that there was some pretty broad consensus on the empirical data that if someone's going to reoffend, they're going to do so within a fairly quick period of time, 3 years, correct?
The information that we had was that the highest level of I don't like the word recidivate. I don't think it's actually a word, but it was used a lot. But it was used a lot.
Recidivist offender?
Actually, to reoffend, but
We'll go with that if you're more comfortable.
The percentage of reoffending after 3 years is significantly lower.
Mhm.
I was surprised by the numbers. Actually, it goes 1, 2, 3, and then drops
Yeah.
to a very low number.
So at that point, after that 3-year period, or whatever it may be, whatever that sweet spot of, reoffending time period is, at that point, downward, not uniformly, but generally, from that point downward,
Well,
there's a
if you-
diminishing returns aspect to that.
For the level of supervision, you can begin to reduce the level, or for a lot of offenders, they can apply to come off of probation. The main thing that we were concerned about was the restitution issue. For
Mhm.
instance, I just had a case where a large construction company was embezzled almost $500,000. Well, the person went to prison for a short time, but had a extremely long period of probation, because paying off $500,000 at $1,000 a month takes a really long time, and so we just after 15 years on probation, we just terminated his probation because he came up with $200,000 and paid off.
Right, and the bill ensures that
Those cases
while
will be handled.
those cases, all restitution can and will be paid, notwithstanding the 3-year, in those, they have to go in and get the restitution paid off.
Yes,
That's
sir.
prior-
a condition.
Yes,
As
sir.
a condition,
That's
a precondition.
of the termination.
Right. Okay. Vice Chair.
Thank you, Mr. Chairman. Just to reaffirm what Mr. Porter just said, I had said this in the subcommittee hearing, but in my years as an assistant DA, I found that common practice on an individual with a first offense typically would result in 5 years of probation, and I would usually do what we called an early termination after 2 or 3 years to kind of put that carrot or incentive in front of folks. And what I found in my years of doing that is that very rarely did the reoffender, the person who was put on probation for a first offense and given that incentive, very rarely did we see them back in court. To the contrary, offenders that we did see back in court for probation revocations are typically individuals, GCICs that stretch criminal histories that stretch several pages, and so that is what I have found to be in my practical experience, and I believe what this is doing is just simply codifying what already is, I believe, a very good practice that provides that incentive, and I think ultimately will result in exactly what Representative Silcox said, that ultimately we'll have less people on probation taking advantage of these incentive type opportunities to be done with their sentence.
I see no further questions. I see no further questions. What's the will of the committee? Ms. Silcox moves due pass of Senate Bill 174 by substitute LC 297550-ECS, second by the Vice Chair. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentlelady's motion, signify by saying aye. Aye. Opposed? The ayes have it. The motion's adopted. Mr. Registration, let's go ahead and just move right into Senate Bill 176.
Yes, sir. This is LC 297544-ECS. Mr. Chairman, Section 1 of this bill provides that when an individual fails to appear in a traffic citation, provides a process with which the court shall issue a second attempt to notify that individual before issuing a bench warrant via letter or postcard. The person will then have 30 days from issuance of the notice to dispose of the charges, and that could be by paying the ticket. It could be by filing a waiver of arraignment and entering a plea of not guilty. What the council found is that sometimes people are issued a traffic citation, they sign for it in lieu of bail. On the traffic citation, there's a court date, and either they lose the citation, forget about it, but these are not career criminals, certainly. These are people just living their everyday life who are busy and forget. What's currently happening is in some jurisdictions that a failure to appear is issued with the effect of a bench warrant. They might be stopped in the future or have contact with law enforcement. They're immediately taken into custody. It might take several days for this to get sorted out. The objective here is to provide, it's a policy determination where we've concluded that the expense of a postcard stamp and the issuance of a postcard is cheaper than having people sit in jail for a day or two or more due to this failure to appear. Procedurally, it would work like this. If a person fails to appear, there would still be, as I understand under this bill, a fair to appear bench warrant type posture, but it would not be signed or ordered until 30 days after the missed court date. And so the clerk's office would issue the postcard or first class mail or letter. That's fine. And this is already being done in Atlanta Municipal Court, the busiest court in the state. I think there's been real success they've seen there. That's section 1 of the bill, and 2, I believe. Oh, by the way, this does not include more serious traffic offenses, DUI, or mandatory suspension license offenses. All right. And with counsel in subcommittee, we added the or waiver of arraignment to make that clear. If somebody doesn't have to pay the ticket after the fact, they could just file a plea of not guilty. Section 3 removes the lifetime prohibition on habitual violator probation licenses if the individual's ever had a controlled substance violation or underage possession of alcohol. What we're seeing here, Mr. Chairman, the reason for this is somebody had say a misdemeanor possession or possession of alcohol charged by a minor or something like that when they were young, maybe later in life. That previous adjudication is preventing them from receiving an otherwise available provisional license issued by the judge due to subsequent offenses that would otherwise cause a suspension. And so the individual would otherwise be eligible because in a very different time in their life, but because of at a very different time in their life, that previous adjudication occurred, they are currently prevented. Section 4 clarifies that a 3 and 5 year DUI drugs for your 3rd and 5 DUI drugs, you should only receive a habitual violator permit if the judge grants it. You should not be issued a more minor controlled substances driving permit, which is occurring right now because of a gap in the law. So we have individuals with 3 and 5, it's much more serious. They should get the more heightened scrutiny for the issuance of a limited permit. And unfortunately, currently for 3 and 5, we don't have that. So we're attempting to address that here. Finally, there's cleanup provision. This is, I believe, lines 164 to 173. We last year had in our bill an overlap on the enforcement dates where 4 individuals in the state were missed and were not the driving permits, as I understand, were not available to these 4 people, and so this would address that with the effective date issue. Would ask for your favorable consideration on SB 176.
On lines 175 to 184, tell us about that. Okay.
It says Article 1 in the last section, instead of Article 2 in the first section.
What Ms. Travis said.
Okay, so that's the gap.
I say that a lot too.
So that's addressing the gap on those individuals?
Yes, sir.
Okay. The effect of the strike on, just if you would repeat the strike, the effect of the strikes on lines 122 to 163. In section 4.
Yes, sir. Absolutely. Sure.
It has to do with this double licensing. And there's the better way to do this issuance of licenses as you see it on line 117 to 118, which makes the rest of that superfluous.
Ms. Travis, is it fair to say with the existing overlap that the lesser scrutiny for the lesser permit, I say lesser, the that the other permit's currently available, and this would, by removing this, only the habitual violator permit would be available.
Because they would be in that status anyway because of their record. So that it's better for the department to do it one way.
And getting the reinstatement is at the discretion of,
That I believe is at the discretion of the Department of Driver Services or an administrative court. I think, as I understand it, what we're talking about here is a judge might have discretion to issue a limited driving permit, or the department administratively might do so as well with the conditions that we've set by law. And so this is to clarify that only a habitual violator permit would be available, not the controlled substances permit, which is, I keep saying, a reduced threshold. Hopefully that makes sense. It doesn't have the same scrutiny that a habitual violator.
okay. But is the reinstatement done by like an administrative law judge, or is it, or?
I believe it's done administratively.
Mr. Porter, I know you're a DA, not a solicitor, but can you or any?
I believe the habitual violator limited permit is a judicial issue.
That's what I thought.
The controlled substances limited permit is done administratively.
Okay. Is anyone here from the council, I guess, of state court judges who could speak to that? No?
We'll say the council worked with the DDS in doing this, and part of this is a function of efficiencies for them.
I know the council, Mr. Abstration, brought some language. What was the language that they brought? I think it had to do with the 30-day, not a continuance, but the missed court date.
Yes, sir. It was an idea from
Judge Studdard.
state court judges, yes, sir, including Judge Studdard. And
specifically, what did that point go to? Do you recall?
well, there were different ideas that were put forward. If I understand your question,
I'm under the impression it was incorporated.
it is, yes, sir.
Okay, yeah. And just if you could just outline what that was.
Yes, sir. It would be the 30-day period. So after the failure to appear, there'd be 30 days until it's effectively enforced.
Okay.
And a reminder sent in the form of a postcard.
The postcard, right. Okay, so I just wanted to make it clear that the judges were engaged on that particular issue.
Yes, sir.
Yeah. Ms. Quick?
Thank you, Mr. Chairman, and Representative Administration. Thank you in particular for Section 1 of the bill for us to have this policy look at this problem, because representing Athens, I can tell you that what happens when these bench warrants get issued in primarily metro Atlanta municipal courts for these traffic violations and licenses get suspended, we're then left to sort out young people being incarcerated with no ability to get them out unless they pay, as a collection mechanism perhaps, off the charges with the metro municipal court. So although this may put an extra burden on our state court judges in some jurisdictions and municipal court judges in other places, I do think it's an important policy discussion for us to weigh in on. So wherever that came from, I'm glad we're addressing it. I do have a question about line 63 of the measure, because I have heard from some of my municipal courts that are smaller municipal courts. I represent Jackson County. We, of course, I don't represent Winterville, but we've got a small municipal court there. This requirement that they have to do this within now 5 days instead of whatever immediately means to them in connection with the operation of their court system in terms of the burden on the smaller municipal courts. I've encouraged them to reach out to their municipal court judge association and reach out to you about that 5-day period and where it came from, but not sure whether they're here on St. Patrick's Day, Friday. Could you tell me what is magic about that 5 days, if anything, and would there be any problem with it being 15?
Well, I think the concern is that we're walking a fine line here as to, we've already given 30 days effectively since the failure to appear occurred. And the concern, I have not heard anything from city clerks or state, or I suppose even Superior. There would be no Superior play, I guess, but I've not heard anything from state court clerks or municipal court clerks concerning a problem with the 5 days. I'll have to ask Ms. Travis, but otherwise, I would just say I know that there was real concern and consideration given to cases falling in the cracks and wanting to make sure that files weren't lost and that things occurred promptly. And with a set time frame, the hope is that routine and protocols could be put in place to ensure that the failure to appear is properly reported after this 30-day period.
Thank you.
Just to add to that, all we were trying to do is, the council was trying to do, was, you've got this word immediate. Immediate is different to everybody. And so with this 5 days, that sort of like shores up what the immediate is. It's 5 business days. That would be according to the code. It doesn't need to be written that way. So it's actually a week that the clerks would have. That was the effort to shore up what immediate was.
And is there an electronic possibility there, as far as the communication? I mean, is that the custom and practice to?
Yeah, I don't know what DDS's communication is with the clerks and if that is done electronically, but certainly if it exists.
I mean, back in the day, 5 days was not a long time, but now, I mean, that's why I asked the question about the electronic potential, about the communication, because then all of a sudden that grants more flexibility than they had. Is that a fair statement? To Ms. Quick, I mean, about your concern?
Yes, sir.
I'm just thinking out loud. I'm
Those are just concerns
asking.
that have been brought to me. I don't practice in the municipal court, but these are the concerns the judges have brought to me, so.
Okay.
The General Assembly, I guess we can only help those that help themselves. So if they're not here to testify and explain it, I don't know that I can do much more than raise the question about the why. I think the author of the bill, well, the House Governor's floor leader has explained the rationale for the 5 business days.
Mm-hmm.
So I think that satisfies me in terms of why it was selected and
And
the
council-
necessity for it, and that it's a public safety concern that the license should be suspended within a certain time frame. So I understand his answer.
Mr. Chairman, there are some courts that can handle the notification to DDS electronically, and of course, there are some that can't.
Vice Chair, did you have something?
Yes, I know that there are some municipal courts across the state that hold court once a month. This is a question, I don't know if anybody in the room has the answer to this, but is a clerk of court of any municipality required to be open 5 days a week? I mean, does anybody have any insight onto whether or not there are places in the state where the clerk's office isn't open for regular business 5 days a week?
So I cannot answer that question. I can tell you that when the issue was, and this has occurred in the House since the bill was passed in the Senate, there was concern that somebody might want to contest the ticket in that 30-day period, and that effectively there was no mechanism to do that, that you would only have to go pay the ticket. So then there was consideration about, well, what if you were able to walk in on another court date? And without giving you all the details of the history, an ultimate determination was made. I cannot tell you what every court in the state does. Some don't meet every month. I imagine there might not be court within that 30-day period. So the filing of a waiver of arraignment, which, as you know, as a practicing attorney, you can mail, you sign the waiver and mail it, and it's received by the clerk. They send the stamped copy back to you. That would be a means by which you could file within the 30-day period in compliance with the statute, regardless of maybe whether or not the court's open 5 days a week or having court over that period. I don't know if that answers your question.
I just wanted to speak to Bert's.
Ms. Ballinger?
I just wanted to speak to Bert's. I have a couple of municipalities that are obviously very small in my district, representing kind of the more rural areas of Cherokee County. And usually it's the only full-time person employed in one of my cities. It's the only full-time person employed by the city is actually considered the city clerk. So she handles all the court documents, so she is there 5 days a week. So usually if they're big enough to have a court, they and have at least one person that's that designated person that is there Monday through Friday.
All right. Any other questions from members of the committee? Mr. Porter, again, I know you're a DA, but any feedback, input from the Solicitors Association that you can speak to?
The association has reviewed the bill as it's progressed, and the president of the Solicitors Association, Ms. Wiseman Baker from Columbus, has been involved in the process, as well as Mr. Kroll, and they've worked with Representative Estration, and they're prepared to endorse the bill and support it.
Great, thank you. Any questions, Mr. Porter, on that end? Are there any questions, members of the committee of Mr. Porter, on that? Seeing none, what's the pleasure of the committee?
Move due pass.
Vice Chair moves due pass of Senate Bill 176, LC 297544-ECS by substitute. Is there a second?
Second.
Second by Mr. Bodie? Ms. Trammell, I'm sorry. Second by Mr. Trammell. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion, signify by saying aye. Aye. Opposed? The ayes have it. And the motion is adopted. Thank you, Mr. Registration.
Thank you.
Indeed, the best for last. We are sorely disappointed that Senator Mullis could not join us this morning. And he may have been here, but he's not here now.
His spirit has always felt.
Pursuant to the chair's discretion, we will consider the bill anyway. Ms. Ballinger.
Thank you, Mr. Chairman. I would like to think that the chairman would rather see me presenting a bill than Senator Mullis.
Oh,
So-
that's a no-brainer, absolutely.
So I bring before the committee the House substitute. As we like to do in the House, we take Senate bills and make them better. LC 297563S is what I'm going from. And it came to Senator Mullis. As you're well aware, his district is contiguous to some of our adjacent states. And it became known to him that a registered sex offender from another state was coming and attending youth events, and to the consternation of some of his constituents. And he wanted to somehow remedy that situation. So it was actually, as a former child advocate, it was a little bit shocking to me that we were basically creating this environment in the state of Georgia where out-of-state perpetrators could come and basically prey on Georgia's children. So we're just closing that loophole in the addition of on line 15, or for any person who is registered on another state's sex offender registry.
Okay, questions for the author, Ms. Kendrick?
Thank you. So this is just a inquiry and question, because I don't know. What happens, does this protect people who were supposed to be registered, but for some reason don't register, or is it in another code section that they have a different, I guess, charge or liability?
No, it only applies to those if you're a registered sex offender in Alabama or something like that. It prohibits you from obviously going to hanging around child care facilities, schools, or any other area where minors congregate.
So if somebody in another state is, and I don't know how this process is, I don't know if they are automatically registered, but if they're in another state that you have to self-register and they don't register and they come to this state, this statute would not cover them.
That is correct, because they wouldn't actually be registered, I suppose. So that was not contemplated, but if you would like to offer a friendly amendment, or should be registered, I guess. But, we were just basically trying to close that loophole for people that had been convicted in other states. We're on that state's sex offender registry and didn't want to create the environment where, all of a sudden Georgia becomes a candy store for them. So just trying to close that loophole.
Yeah, I was just wondering
Yeah.
if the intent was to keep people
Exactly.
who weren't supposed to be near it, what would happen if they were not registered, were supposed to be registered, and they came here? Because I don't know if they're covered in another part of the code section, but then they wouldn't be prosecuted.
Yeah,
They couldn't be
they
prosecuted.
couldn't be prosecuted under this statute. However, I am not sure. I just can only speak from, my experience in the state of Georgia. It's the likelihood of being convicted and not registering is just, everybody pretty much that needs to register usually does. So.
Ms. Dickerson.
Thank you, Mr. Chairman. I don't know if she asked the question or not, but how would they know that they would have to be registered? How would they be notified if they came in like this gentleman did?
Well, there would be a registered sex offender in Alabama.
I know, but coming to
And-
Georgia, they would have to register in Georgia.
No, they would not have to register as a sex offender in Georgia. There is a procedure by which, if you want to move here, if you're here for more than 14 days, then you have to register as a sex offender with our Sex Offender Registry Board here in the state of Georgia. However, if you live, just across the state line in maybe Tennessee or Alabama, South Carolina, North Carolina, or any of those states surrounding us, and you're on that registry, it just creates it kind of prevents them from coming to youth athletic events, buying the kiddie snow cones. They start that grooming behavior with some of our children. Unfortunately, under Georgia's law, without this being added to it, that's okay.
Okay, thank you.
Mr. Bodie.
Yes, Madam Chair. So basically, the intent is for someone that's visiting. Is that correct? Like a visitor from out of state?
Well, specifically people that are in those states, kind of contiguous to the state of Georgia. Obviously, there's usually grooming behaviors and repetitious behavior that would be part and parcel. But right now in the state of Georgia, there's no way to tell those people to get away from our kids.
Yeah. Okay. Thank you.
You're welcome.
On Ms. Kendrick's
I think.
question regarding an individual who is here from another state who is supposed to be registered on that on the registry, supposed to be on the registry in another state, but is not. Let me call on council to speak to that. Are those individuals already covered under the code? They are.
Okay.
This is indeed just a visitor bill, and if you look at the title of the bill on line 5, that's what this is covering. The other aspects have been covered in current law.
Thank you. Does that answer the lady's question? Okay. Any further questions for the House sponsor? Mr. Porter, you have any comment?
Your Honor, we worked with both Senator Mullis and the chairman to help with this. It's a very elegant solution to a problem that arose in several areas of the county or in the state. And we started out with a lot of movement, and just changing these few words is a pretty simple solution that will solve that problem.
Ms. Kendrick?
I know y'all ready to get out of here. I just want to make sure.
That's all right.
I just want to make sure I understand. So there is a provision under the code. So if somebody comes from another state and they're supposed to be registered and they come here and they do not register, then there is a separate offense for them not registering.
Yes, there is a compelling process whereby if you're going to be here for more than 14 days, if you're here for school, if you're here for employment, you have to register in the state of Georgia as a sex offender.
Okay, so that they would be violating that
yes.
part. But would they be violating, like, would it still be unlawful for them to be around these facilities?
Perhaps D.A. Porter could speak to that.
The first question would be they'd of course be in violation of their own state.
Right.
So probably the actual process would be, and I have to go back to the genesis of this bill, is this came about because a registered sex offender from another state was going into a county in Georgia and going to youth sporting events, buying kids snow cones and basically hanging around, and they couldn't figure out a way to stop that, and that was the genesis of the bill. If you had a situation where that same person came in and was required to be registered, and it was discovered that he had failed to register, probably the way you would do that is report that to the other state authorities, who would then issue a warrant for failure register, which you would then serve and extradite him back. The problem from a practical standpoint is, how do you know that it's very difficult to find out a person is supposed to be registered but isn't. That's the real difficulty I see in that question. If you were to discover it, there's an easier way to handle that issue.
Thank you.
Any further questions? Seeing none, what's the pleasure of the committee? Mr. Trammell moves due pass of Senate Bill 250 LC 20 by substitute LC 297563S, second by the Vice Chair. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you, members of the committee, for, again, being here so we can move these bills out, get that off our plate. We will, again, we will be meeting Monday and likely Tuesday morning as well, just for planning purposes. Anything else from members of the committee? Any questions, concerns? Seeing none, we're adjourned. Thank you.